Thank you. Please be seated. Of course, I do need to first verify that they can hear and see us. I'm getting the thumbs up. We are back on the record. The record should reflect that Mr. Brooks is no longer in the main courtroom. He is in the adjoining courtroom. I, of course, have been erring on the side of constitutional caution, but I would note that his right to be present at sentencing is a statutory right, which, frankly, I probably don't need to go through the findings under Illinois versus Allen, but I did. But under whether it's a statutory right or a constitutional right, you can forfeit that right, and his behavior today has certainly demonstrated that he has forfeited his right to be present in this courtroom during my sentencing remarks. He immediately came in. I was on the bench looking through my paperwork. The courtroom wasn't even open. And he started asking me questions. I said I wasn't going to answer them. He really had no respect for the proper decorum. I needed it to be on the record. He didn't seem to care about that. Wanted to debate me about my prior rulings. Bottom line is it's a statutory right for him to be present, and he's forfeited that right. And I would just add that it's part of a pattern that has been demonstrated during this trial, that when my perspective, things are not going in his direction, things are being said that he doesn't agree with, that he tends to act out, he disrupts, and I'll leave it at that. Once again, I'll confirm he can hear and see. We've got confirmation from the staff in the other courtroom. One of the reasons I really spent the time going through both my observations of Mr. Brooks in terms of the mental health related issues, and first, and then going through the victim impact statements before I go through all of the necessary factors for sentencing, is frankly it's challenging to talk about the impact to the victims without getting emotional. This trial is unlike anything that I've ever been a part of. The sheer magnitude of the crime, the number of people impacted, how they were impacted, the vicious, senseless nature of it, and hearing about the impact of all of that on our community members and the people who were at the parade, it's heart-wrenching. And I wanted to do that before I really got to the meat of sentencing, because I also thought it was important to really spend some time recognizing and acknowledging the impact to the direct victims who are in this courtroom and who have provided statements. Today, my focus in sentencing will be about November 21 of 2021, the events shortly before that or leading up to it and after, and are not about Mr. Brooks's conduct during this trial, even though case law is very clear that his conduct at trial can and is a legitimate factor for the court to consider. I need to make the record very clear that in no way what I do here today is based on Mr. Brooks exercising his right to a trial. That is a firmly embedded constitutional right, which I support, which I upheld. Of course, every person charged with a crime has a right to a trial. This court honored that right. I protected that right, even if Mr. Brooks treated it with contempt, disrespect, and at times like a game. But sentencing today is directly related to his conduct on November 21 of 2021 and the other sentencing factors, which, as I indicated previously, include the seriousness of the offense, the need to protect the public, and his character and rehabilitative needs. Today I am tasked with sentencing Darrell Brooks for 76 counts related to a couple of moments in time. Moments that are tragic, moments that were frankly avoidable. My sentence here today is, the purposes of it are twofold, really threefold if we think about the community. One, it is punishment. Two, protection of the community. And three, what I hope is justice and closure for the families and the community at large. I, of course, want to recognize and give due respect to the guilty verdicts that were rendered by the jury in this case. Not just 76 guilty verdicts, but the special verdict questions that they answered, including for counts 1 through 6 and 7 through 67 that had the special verdict question related to the use of a dangerous weapon. So let me talk about the seriousness of this offense. The seriousness of the offense can be summed up, frankly, in one word, and that is attack. There is nothing, no other word that can best describe what happened on November 21 of 2021 than the word attack. I talked about, during my remarks regarding the trial, about the opportunities that Darrell Brooks had to avoid this altogether. I put Exhibit 15 on the screen for a bit, which is the exhibit that details the map. The map of the parade. It starts with White Rock. It shows where Sergeant Warner was at one point, farther up that parade route, the staging area, and I believe if you look further up on Exhibit 15, it even depicts where White Rock School is, and that, of course, is where we saw the video of the altercation between Mr. Brooks, Corey Runkle, Nicholas Kirby, and Erica Patterson. Now, of course, there were moments in time before that, but that is really where things started, where I believe Mr. Brooks boiled over with rage and anger that he chose not to control on this date. He had a number of opportunities to simply drive in the other direction down White Rock, but he chose to drive toward Main Street, even though from the testimony we know it was very evident that it was staging for a parade. There were many people, may not have been exactly by the school, but farther down White Rock. From Niagara forward is where that staging area was located, and many people were there. The sights and sounds of a parade, the signs on the side of the road telling people not to park there, for example. Instead of turning around, or instead of turning left onto East Main Street or left onto Pleasant, and despite Sergeant Warner trying to flag him down and being in front of a squad with lights and a clear indication you should listen to or honor the even gestures of a police officer, and he was in uniform. He drives down White Rock Avenue and has contact with Detective Casey, who very clearly did everything he could to stop Mr. Brooks. And in that moment, thinking it's a lost motorist. But Mr. Brooks chose to basically brush him aside with that SUV and drive on to Main Street, past more people, past many spectators, and in a manner that was not just at a speed inappropriate for a parade, but frankly, that was reckless and endangered anyone who was on the roadway at that time, whether or not he hit anyone between White Rock and Main and Barstow and Main. But during that 3-block section of Main Street, he could have turned off Buckley, Northeast Avenue, Martin Street, or in either direction on Barstow. He could have stopped, asked for the police barricades to have been removed, or frankly turned his car around even at that point and gone back the way that he had come. But he didn't do that. He chose to drive recklessly, carelessly, and maliciously through a parade route and at anyone in his path, where he struck not one, not two, not three, but 68 different people. We actually know that number's higher because we now know, we heard from the 2 individuals who were with Extreme Dance, the one girl who was struck by one of the individuals who was clearly struck, and that person flew into her. That would qualify for a charge based upon the state's description of how they chose to charge. It's just they didn't know until closer to the sentencing hearing. So 69 individuals if you include her. There are so many aggravating factors here, it's frankly difficult to even keep track of them all. The complete disregard for the lives of anyone else that day. Someone described it as depraved indifference, and I think that is the perfect phrase to capture the actions of Mr. Brooks on November 21st of 2021. The aggravated factors of the numerous opportunities to turn around or not even enter the parade route or simply to stop. The fact that he mowed over and used that vehicle as a battering ram to hit 68 individuals, never once stopping, with rage and anger at unsuspecting people at a parade who were there simply to kick off the holiday season, to experience joy with their families. The intentionality of the conduct is outstanding. The viciousness, the speed, the swerving from side to side at various points. This was not a case of whodunit. From the very beginning, from when this case was charged, it was clear who did this. Now, that is not to say that I prejudged this case. I did not. But after sitting through this trial, after watching the many videos, after listening to the testimony of the many, many dozens of witnesses, it is clear the state had overwhelming evidence of Mr. Brooks's guilt. What's also aggravated is his complete and utter lack of remorse. He spoke here today for 2 hours. One sentence, that's it. I'm sorry. No detail. 2 hours, one sentence. No empathy for any of these individuals, at times mocking them with hand gestures or rolling his eyes multiple times. That is not an indication or a sign of someone who has empathy, who is sorry for what he has done. We may never know the true why, but we were provided with nothing here today other than a feeble attempt to blame mental health, which frankly does a disservice to those who truly suffer from mental health issues. I understand why his family might cling to that because of the difficulty in coming to grips with a loved one doing such heinous things. But for Mr. Brooks, it's nothing more than indifference, deflection, and outright denial of what he did and the impact that he has caused as a result of his heinous actions. I searched for a mitigating factor in this case. I waited patiently for an apology, a true apology. I didn't get it. And not for my benefit, but for the victims. The law allows me to look at things such as Mr. Brooks's prior criminal history, including the history of criminal offenses and pending charges, the history of undesirable behavior patterns, which can include dismissed, uncharged, or unproven offenses or facts, even including expunged offenses not really relevant here, acts resulting in probation revocation. Of course, those are part of his criminal history, nothing specific to these charges. I can look at his personality, character, and social traits, the vicious or aggravated nature of the crimes, the degree of his culpability, his demeanor at trial and truthfulness, his age, his educational background and employment record, his remorse, repentance, and cooperativeness, his need for close rehabilitative control, the rights of the public, the recommendations of the interested parties, including victims and family members of homicide victims. I can consider statements made by his own family. I can certainly consider the length of pretrial detention, which I'd note, though, when facing 6 life sentences, is really a fraction of the time available to this court. The loss of life in this case is certainly one of the aggravating factors here today. The number of people injured, also an aggravating factor. The reach into the community, certainly palpable because this was a Christmas parade. I think it was a comment earlier, either today or yesterday, that this was not like one act where Mr. Brooks drove into a crowd of people. This was sustained driving from block to block to block to block, picking off people that were unsuspecting, 68, 69 times. Driving over people as if they were nothing more than speed bumps. What's also aggravated is his conduct after he drove through the parade. Crashing his vehicle in an attempt to flee. It's pretty evident based upon the evidence and testimony from trial that Mr. Brooks had no idea there were these logs in that backyard that could damage his vehicle. He was attempting to flee when he ran over them, and it ultimately disabled that vehicle, and he was forced to abandon it. He ditched it, leaving personal identification information in it and his phone in a clear attempt to get out of there in a hurry. And then we have that series of videos that we saw at trial of him going through backyards, coming in contact with people, asking to use phones, ultimately ending up at Mr. Ryder's home, who graciously took him in. Never once, Mr. Brooks showing any signs of distress, of any emotion of what he had just done. Cool, calm, collected. Certainly not a sign of someone who had any remorse for what he had just done. Someone who's involved in an accident, even a tragic accident, one where they flee the scene and are later caught, oftentimes show incredible remorse, tears. Not tears for themselves, but tears for what they've caused. A recognition of the loss of life, for example, from their conduct. Nothing. An individual who simply wanted to flee. That is the epitome of consciousness of guilt evidence. Fleeing, changing your appearance, taking off the sweatshirt, not even caring that your shoes are off your feet because you're so intent on fleeing the area. Putting your hair up from it being down. No doubt, this is by far and away one of the most aggravated cases I've ever presided over. The sheer magnitude of the loss, the number of victims, the types of crimes for which the jury has convicted him. 6 counts of intentional homicide, 61 counts of first-degree recklessly endangering safety, 6 counts of hit and run, 2 counts of felony bail jumping, 1 count of misdemeanor battery. What's further aggravated is the fact that he was out on bond. He should have had no contact with Erica Patterson. But the rules mean nothing to Mr. Brooks. Nothing. He didn't care. This was someone who on two prior occasions charged with, frankly, causing mayhem. One, a reckless endangering safety for discharging a firearm. The other for battering and then running over Erica Patterson's foot. This court does get to consider the other act's evidence that the state sought to introduce at trial. That other act's evidence includes that on November 2 of 2021, Milwaukee police took a complaint from Erica Patterson that Mr. Brooks had run over her with his vehicle and tried to kill her. She had tire marks on her right pant leg She could not move her leg and had blood coming from her mouth. On that date, Mr. Brooks was driving the same vehicle that he drove through the parade. Erica Patterson was conveyed to Frederick Memorial Hospital. Her injuries received medical attention. She even had that boot on her leg on November 21 of 2021. She described Mr. Brooks to police as yelling at her, using profanity, as she tried walking past him when she was at a gas station. I think initially before that, at another location, but ultimately where he allegedly ran over her was at a gas station and caused the injury to her leg. Struck her in the face once with a closed fist, causing pain and bleeding without her consent. And then it was after she walked away that he followed her. When police had contact with him, he denied driving his mother's vehicle. When police had contact with him at his house, he ignored their commands because he was found in the vehicle, claiming that he was having an anxiety attack upon the sight of the squad car and needed to get into the home to get his inhaler. When I say the rules don't matter to Mr. Brooks and court orders mean nothing, Mr. Brooks was in custody, and there are jail phone calls where he's berating Erica Patterson, encouraging her to recant, blaming her for what had happened, saying things on that phone call like, "You trying to make it seem like everything is always everyone else's fault but yours. Like you don't never do anything to cause shit. And the whole cause of this shit was something that you fucking did." He ended the call by telling Erica Patterson, "You did this shit, and you couldn't even keep your mouth shut after numerous people told you that shit. This ain't the place for you to be doing this shit, and you still ran your mouth. And I'm the one sitting in here facing all this time." Repeatedly calls her a bitch. During a phone call on November 11th, Darrell Brooks is overheard or captured saying, "Why in the hell would I just try to mow her down knowing I could kill her like that? Like, okay, I probably got a few screws loose, but I ain't hardly no goddamn fool." He's complaining that she won't help post his bail. "You didn't put a cent on my bail. Why should someone else have to pay for some shit you caused?" The end, apparently, of that conversation, or at least moments later, he says to her, "Nah, I didn't try to do anything, because if I tried to do something, you wouldn't be on the phone now. That's what you're not realizing. If I really tried to do something, you wouldn't be on the phone now." That is the rage and the anger that Mr. Brooks had on November 21 of 2021 when he tracked down Erica Patterson, confronted her. This wasn't about him getting money from her, like he lied to Detective Carpenter about. This was to confront her. He clearly hit her, we know that. This is the type of man that drove through the Christmas parade, enraged because, frankly, It's entirely possible that Corey Runkle and Nicholas Kirby saved the life of Erica Patterson. It's clear Mr. Brooks was hell-bent to cause harm to her, but she was able to get free, run back to her friends. Who knows what would have happened but for their intervention?